So right now we're not exactly sure what the defense is.
You never
Right,
filed,
right. And I'm saying call her
never,
and she'll tell you all.
that isn't how it works.
Well, it should have
Do.
been, because I shouldn't be here getting upset, and you shouldn't have to deal with me.
I wish it were true.
The judge wastes no time noting the importance of this case. You can feel the weight building. This isn't traffic court, it's civil court with serious money on the line. The tone is tense and raw, and this intro sets the stage for a total legal disaster in slow motion. Roberts wants sympathy, but is walking into a legal grinder.
A telephone that I don't know who that is.
That would be Bradley Roberts, Your Honor.
All right, Mr. Roberts, you're late for your own hearing, but you are here.
I have tried to get my stuff downloaded and had kids helping, and nothing is working. So thank God for the phone number, because I don't have a ride.
All right, well, this is a court appearance, and it affects a lot of money, and people really should take things more seriously than they do. But let's talk about this case. Attorney Tiffany Palmer is here.
The judge starts detailing the case, and it's clear this isn't a simple misunderstanding. Liberty Mutual is coming after Roberts for over $10,000 and is acting like it's just a mix-up. The timeline reveals missed hearings, ignored procedures, and a tangled mess of names involved with the uninsured vehicle. Plaintiff's attorney Tiffany Palmer is present, professional, and ready. Meanwhile, Roberts is still fumbling over basic facts. With every word, it becomes more obvious. He treated this like a casual call, not a serious legal showdown. The courtroom is watching a slow but steady breakdown of responsibility.
On behalf of the plaintiff.
Good morning, good afternoon, Your Honor. Tiffany Palmer on behalf of plaintiff P number 74809 for the record.
And Mr. Bradley Roberts is here by telephone only.
Yes, sir.
All right, this is a claim by Liberty Mutual Personal Insurance Company versus Bradley Roberts. And this has had a bumpy ride. We've had a couple of previous hearings on this. We had a hearing on March. Let me go back even all the way to the beginning. We had a hearing on December 16th. Mr. Roberts appeared. He admitted there was no insurance on the vehicle at the time, and it was screwy facts. The vehicle was allegedly owned by Cindy Vandegrift. It was insured as Jessica Adams, and the vehicle was driven by her son or nephew, Xavier Adams. Anyway, there was an accident, and no police report was filed, and so all these facts were raised, and so they continued the matter for 90 days for additional discovery. Mr. Roberts didn't show up. We discontinued the matter to March 31st, 2025, and Mr. Thomas Duquette was here. So we adjourned the matter for 90 days for discovery, and the defendant never complied with any of the discovery. So he didn't answer any of the plaintiff's requests for discovery.
All right, guys, now it really gets wild. Roberts didn't just miss court once, he ghosted discovery completely and didn't comply with any requests. The judge explains how the court gave him time, grace, and multiple opportunities, but he failed at every turn. A default judgment was entered against him, over $10,000, including damages and costs. Roberts tries to throw someone else under the bus, but it's too late. The facts are on paper, and the judge isn't interested in revisionist storytelling. It's a key moment where you realize Roberts dug his own legal grave, and now he's scrambling for a ladder he never built.
And he didn't show up for the court hearing. So Mr. Duquette moved for a default judgment. $10,415 in costs, in damages, $232.13 in costs, and a $75 attorney fee. So a judgment entered by default on March 31st.
Which should have never happened. You heard me say she jumped in it and started it and put it in reverse. She took control of the vehicle. It was hers, not mine. She's
All right, well,
using mine to go to work right now, or I'd have a ride there.
okay. Well, you didn't show up for the hearing. That's not her fault.
And
We
I
had a
paid
hearing.
someone that day. I paid someone that day, and they didn't make it to come and get me, and I walked home from work
Well,
to make sure I got on the Zoom.
all right,
I'm
well,
sorry,
well-
but this is making me mad. I shouldn't even be here.
Well, that's open for discussion. You think you shouldn't be here. They have a different idea about
Exactly.
it.
Well, when
Because
someone
the
jumps in a
insurance
vehicle, they assume responsibility.
Do you have a legal citation for that? Or is this something you read on the back of a cereal box? You're under the no fault statute and it's complicated. And you're in over your head. So you don't show up for your hearing. You don't answer any of their requests for discovery. They sent you information. Everything you've told me, none of it's under oath. This happened, it belonged to somebody, somebody told me they backed into the car. None of it's under oath. It's just what you claim to be true. So they send you a...
Things take a sharp turn. Robert starts arguing insurance law as if he read it off a cereal box, and the judge calls him out, hard. It's awkward, even painful to watch. He's quoting statutes he can't explain and trying to reason through things well above his head. He doesn't understand what discovery even means, and he admits he's no lawyer. That's clear. The judge is fair but firm, pointing out that court is not about feelings, it's about facts and procedure. Roberts is drowning in his own confusion, and everyone in the room knows it. This is legal reality hitting someone who never took it seriously.
number of
Well,
documents for discovery, and you don't answer
I don't know
any.
what that means.
Well,
I don't know how to do all that. I'm not a good lawyer. I don't have any help. I couldn't hire an attorney because no one would take the case.
yes, it's a tough
I'm tired of
situation.
getting ragged on when I'm trying.
All right, well, all right. You may be trying as hard as you could. Maybe you could spend $50,000 for a lawyer and the no fault statute still applies. So anyway, you don't respond to the discovery. Everything you're telling me, this isn't how the legal system works. You show up and say, hey, judge, this is all a big mistake. Sorry, here's what really happened. Please dismiss it so I can go home.
They're doing.
Well, they filed legal pleadings.
That should have never happened.
They're here to provide testimony regarding the matter. In fact, we took some testimony, or at least some legal representation, on March 31st. So anyway, you don't show up on March 31st. A judgment enters a few days later, and you file a motion to set aside the default on April 14th, which it was in 21 days of the default setting aside. So when you move to set a default aside, there's a certain standard you have to meet. You're supposed to file something called an affidavit of meritorious defense.
Roberts throws everything at the wall. Tablet problems, long walks, bad timing, no help. He says he tried, but the court needs more than stories, it needs proof. The judge reads his motion to set aside the default, and nothing stands out as a valid legal reason. He says someone else borrowed the car and caused the accident, but there's no affidavit, no sworn testimony. It's all just verbal spin. The timeline doesn't line up, and the court isn't swayed by emotion. The gap between effort and actual legal compliance is massive here. He's out of options, and the courtroom is growing more skeptical by the minute.
And you're supposed to show good cause for why you did not appear for the hearing. So in your motion, which you filed on April 14th, I'll just read it. On March 31st, a person who lives with me borrowed my vehicle to look for a job. I totally forgot. Although I called the court around 8:05 and left a voice message as I was going to be late because of no ride. So I walked a couple miles, got a ride. Then when I was home and on Zoom, for some reason, my tablet would not work, the microphone, no matter what I did. I have a meritorious defense for this claim. I, Bradley Roberts, and Keith Ryan, seen Cindy Vandergriff, also who own a 2005 GMC Envoy. Cindy got in the vehicle and started it and then reversed it, which in turn slammed into the plaintiff's parked vehicle, knowing the vehicle had no insurance. Therefore, knowingly take possession of said vehicle, the plaintiff then left the scene. No police were called, And somewhere, someone later gave the plaintiff an old insurance card which had my information on it.
Correct.
Which is different than what you told me at the hearing back in December of 24. So I'm not sure that establishes an affidavit of meritorious defense or a legitimate reason for not coming. I don't have any notes in the file that you called. I don't say that you didn't. The hearing was at 8:30. At any rate, I called the hall and checked around and you weren't here.
Here's where it all begins to crumble. Roberts tells a different story than what he said months ago. This time, he blames a woman who supposedly jumped into the car and caused the accident. But earlier, the version was completely different. None of it is sworn, none of it proven. The plaintiff's attorney points it out. These contradictions matter. If you can change your story this easily, how can the court trust anything you say? Roberts has zero supporting documents. No evidence, no consistency. His entire case rests on shifting sand, and now even that's starting to erode right in front of the judge.
So having laid the premises out, Ms. Palmer, what's your position here?
Our position is that the defendant has not met the statutory burden in order to set the judgment aside. As the court has indicated, the information he provided as to his failure to appear for a court-ordered hearing, it doesn't rise to the level of good cause, but obviously the court is the gatekeeper of that. But our position is that it does not rise to that level. And then the meritorious defense that was advanced, it is not necessarily consistent with what was originally indicated. And this could have been helped if the defendant had answered the discovery. So right now we're not exactly sure what the defense is. And although I know the courts are somewhat liberal as it relates to advancing a meritorious defense, this is an affidavit. So I couldn't even necessarily use this statement if the court was inclined to set aside the default judgment to impeach him or to have him basically attest to these facts. So he could theoretically change his version after this point too. So we believe that he has not met the statutory requirement to set aside the default judgment at the bare minimum.
Let me see if I understand. Mr. Roberts, are you contending that this is a completely different vehicle?
No. No, it's the same vehicle. I gave them.
Roberts now insists this whole thing is simple. Someone else drove the car, someone else caused the damage, so why is he being blamed? The answer is legal accountability. He held the insurance. That makes him liable, no matter who was behind the wheel. The judge makes it clear, ownership, registration, insurance responsibility, it all points back to Roberts. He keeps circling back, saying the plaintiff should have just called the other woman. But this isn't detective work, it's civil court. And he missed every chance to do what the law required. Blame shifting won't save him now. The clock is running out.
Her phone number, all they got to do is call her and talk to her. I thought my stuff would be taken care of and thrown out because I shouldn't be here. She said, here's my information, and she lives with me still. You know, it's simple. Contact her and not me. I didn't do it. And they haven't contacted her at all.
All right, but one thing that you, from the beginning, failed to accept is that you're the insurance holder on the vehicle.
Yep, I was. That's what started all this, because someone got my information.
Yes.
So, and I'm not sure if this is the right way to do this, but I was confused in what his defense was here. I thought he was saying it was a vehicle that looked exactly the same as his vehicle that was completely separate. So he's saying that someone got into his vehicle and then drove the vehicle. Is that what this defense is here?
Yes, she got into her 2005 Envoy and yes, drove the vehicle.
That you were the insurance holder on.
Well, used to be at that moment though, and she knew there was no insurance on it because it had lapsed. I wasn't driving it. It was parked.
Your Honor, based on the defendant's statement, and I understand he's not under oath. And I misstated maybe in how I responded to the meritorious defense.
This is where Judge Middleton truly lays it bare. Roberts tries again to tell the tale. The car belonged to Cindy, he insured it temporarily, then stopped using it. But he provides no documentation, no title, no evidence. Just words. The judge isn't moved. He says the whole situation reeks of people playing games. One person owns the car, another insures it, someone else drives it. It's a legal mess with zero clarity. And without proof, Roberts is sinking deeper. The court can't fix what he never properly showed. This isn't just a lost case, it's a textbook crash course in how not to defend yourself.
But if he was the title owner, registrant, or constructive owner of the vehicle, he's still legally responsible for whoever's driving the vehicle if they had permissive use.
Yes, he doesn't understand. But his argument is...
But then when she jumped in it, yeah.
She drove it all the time. You guys were playing fast and loose with the rules. The car was titled in somebody's name, insured in somebody's name, driven by somebody else. There's an accident and the insurance is in your name and now you're outraged. It's your own fault. Then none of this is under oath. I don't know who this car is registered to. I don't know that she's the registered owner. I don't know all this other stuff you told me on December 16th. What you told me in the other letter is different.
Somebody's getting confused because it's simple. Cindy Vandigrift is the owner. I borrowed it because she wasn't driving it, so I insured it. Then I quit driving it, and it was parked. Cindy Vandigrift's still the owner. And then Cindy Vandigrift day,
all we know about that is what you're saying here, and you're not under oath. You never filed.
Right, and I'm saying call her and she'll tell you all.
That isn't how it works. They sued
Well, it should have been, because I shouldn't be here getting upset. And you shouldn't have to deal with me.
Well, I wish it were true.
Yeah, I know. Okay.
All right.
I'm sorry.
So they send you a bunch of documents to ask you these questions. Who's the car registered to? Show me the title. Who was your insurance carrier? When was it insured? You didn't answer.
This part is a harsh legal reality check. The judge patiently explains that civil court isn't a guessing game. You don't get points for trying. You get rulings based on what you file, say under oath, and support with evidence. Roberts didn't do any of that. Discovery wasn't answered. Interrogatories ignored. Affidavit of defense never submitted. The judge isn't being cruel, he's just being real. This is what happens when you walk into court unprepared and uninformed. Roberts may be frustrated, but the law doesn't run on confusion. This isn't personal, it's legal, and he failed every requirement.
I have the title if I don't own it. So I have no idea to fill this stuff out. No idea how to do it.
So all you have to do is show up and say, hey, I don't own this. I don't have any proof that I don't own it, but they're showing that you're the insurance
I did that the first. Wouldn't that be the first meeting we had when I left them her phone number and contact info? It would have been taken care of. If they would have followed through and said, okay, you're not the owner, I'm going to call this number, they would have found out who the owner was legally.
All right. Anything
I can get
further?
on Michigan website and do that.
Your Honor, just in response to defendant's last argument, obviously it's not appropriate to somehow switch the burden to the plaintiff by saying that we were supposed to call and then I guess somehow add her to the lawsuit. We don't have anything definitive to even be able to sue Cindy upon. Maybe if he answered discovery, maybe if he had sworn statements, any of those things.
I
But he just has his versions that he is,
I see what
advancing
you're
that
saying,
we cannot rely
but I
upon,
didn't understand.
that we cannot rely upon. So that's why it was critical, and that's why the court opened discovery and allowed us to have discovery for him to answer discovery. That's why it was important. And if he didn't know the answer to a question, could say he didn't know. It's plenty of questions on here. I think 12 interrogatories, 5 requests for admissions, and a request for production, I believe. So it's quite a few questions on here. First one being his name.
And I didn't understand how to. I
Mr. Roberts, you point out a good and valid point. People get involved in a general civil lawsuit. They don't understand the rules. It's complicated. You're not in small claims court, you're in general civil court. And every day this week, including tomorrow, I have multiple people who are driving around with no insurance. And last week on Thursday, I had 7. Probably had 10 last week. I probably have 10 this week. And you point out what happens when you're driving around without insurance. You get into the weeds when you get sued by the other party's insurance company for an accident. And you're in the weeds, all right. You barely filed an answer. You didn't show up for the hearing. You didn't answer any of the interrogatories. And you haven't shown an affidavit of meritorious defense. And I'm not sure we have good cause for why you.
And here comes the final gavel drop. The judge officially denies Robert's motion to set aside the judgment. He goes step by step. No affidavit, no discovery, no good cause, and too many conflicting stories. He even points out how pointless it would be to sue the woman Roberts blames. No money, no proof, no results. It's a courtroom reality check. The judge reminds everyone why insurance, ownership, and court appearances matter. Roberts didn't just lose this case, he became an example of how skipping steps turns a bad situation worse. Make sure to like the video, subscribe to the channel, and we'll see you in the next one.
Weren't here. So your motion to set aside the default is denied. Good cause and meritorious defense were not established. Now, you can sue her if you think she's more liable. She doesn't have any money either, and I doubt they're going to get any money out of you. But
100. When she jumped in it and started it, isn't that taking for the known possession of the vehicle back?
No, it's not.
It
It's
would be
not.
under her term. Okay.
No, it's not. All right, I'm going to send you an order denying your motion. And if you want to appeal that further, I guess you're welcome to do that. But for the reason stated, you are liable for the amount here. You can't even get to court. You have to call by telephone. And
yeah, so, this is why our country works great. Because Cindy's using my car. I said that.
Sorry about Cindy using his car, but that isn't going to go very well forward. But for all the reasons I stated, he didn't show up for the hearing. He didn't answer the interrogatories. He didn't show necessarily good cause for why he wasn't here. He didn't file an affidavit of meritorious defense. He filed he said two different things about what actually happened, none of which was under oath. And he just doesn't understand, and he'll be mad no matter what I try to say. So this is another case of it is what it is, and another abject lesson for don't drive around without any insurance on your car. And don't have somebody own it, somebody else insure it, somebody else his nephew or son drive it. When the wheels fall off, it can be very expensive. All right, Ms. Palmer, maybe we'll hear more about that, or maybe we won't, but I've denied his motion and I've signed the order to that effect.
Thank you, Your Honor.
All right, thank you.
You have a great evening. Afternoon.
All right, it'll get better after this. I said I got 4 clunky small claims on a criminal case, so I probably got more people that won't like my rulings, but we'll just
Well, have fun, Your Honor.
right, thank you.
This part is a harsh legal reality check. The judge patiently explains that civil court isn't a guessing game. You don't get points for trying, you get rulings based on what you file, say under oath, and support with evidence. Roberts didn't do any of that. Discovery wasn't answered. Interrogatories ignored. Affidavit of defense never submitted. The judge isn't being cruel, he's just being real. This is what happens when you walk into court unprepared and uninformed. Roberts may be frustrated, but the law doesn't run on confusion. This isn't personal, it's legal, and he failed every requirement.